from our July 21st meeting. I'll ask if there are any additions or corrections to those minutes.
Yes, Chairman Farmer. On item 2, I would like to have the minutes reflect that at my request that we would, the commission agreed to have the sheriff's office appear before the commission to discuss its procedures regarding the women inmates.
Okay. We can't force the sheriff to come before the commission. So if it's just simply a request, that perhaps the minutes should reflect that it was a request, but certainly not a demand. Are there any other additions or changes to the minutes? Hearing none, I'll entertain a motion that they be approved as submitted with an addition of Commissioner Sanders' request that the Sheriff's Department address the commission on their policies.
I move approval with the amendment.
Second.
All in favor? They'll be approved. Next item, union representatives. Who's here from the unions? Mr. Officer Smallwood, are you here? FOP. FOP's here.
SEIU's here.
SEIU's here. Well, welcome. We have the announcement of the appeals process. Ms. Icky.
Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that a contested case hearing before this commission, which affects the employment status of a civil service employee, is appealable to the Chancery Court of Davidson County, pursuant to the provisions of the Uniform Administrative Procedures Act. Any such appeal must be filed within 60 days after the entry of the Commission's final order in the matter. A common law writ of certiorari is the appropriate appeal process of any decision of this Commission that does not involve a contested case hearing affecting the employment status of a civil service employee. This appeal must be filed within 60 days of the action taken by the Commission. You are advised to seek your own independent legal counsel to ensure that your appeal is filed in a timely manner and that all procedural requirements are met.
Thank you, Ms. Icky. Has any minister had any communications from any member of the public on any pending hearings? Hearing none, we'll go to the approval of the appointments, terminations, and pensions, and the eligibility register report. Director Hall, are those in order?
They are, Mr. Chairman.
Any questions of Director Hall concerning those items? Hearing none, entertain a motion they be approved as submitted.
Motion to approve.
Second.
All in favor?
Aye.
They'll be approved. Departmental items. Number 1, review of the initial order of default and dismissal, Michael Burham Water Services, a termination issue.
Good morning, Commissioners. Tara Ladd for Metro Legal.
Ladd? You want to tell us what this is about?
Of course. Michael Burham was an equipment operator senior for Metro Water Services, and in short what that meant was that he operated a trash truck, which required a CDL license. He, around August 18th, as you know, they're subject to random testing. He was sent for a random test. Metro Water Services did not have those results back. Then on August 30th, Michael Burham entered into a very narrow alley and struck the side of a house, causing $3,000 in damage to the truck and over $7,000 in damage to the person's house. There was testimony given in the civil service hearing that he should have never driven the trash truck down that alley. It was too narrow for that. He never would have made the turn. In the meantime, Metro Water Services received the results back from the random, and he was positive for marijuana. They moved toward disciplining him on that particular piece, gave him their standard discipline, the 30-day suspension, demotion from his job. Then afterwards, they convened to discuss the striking of the house. And some of the things they took into consideration as well is that he'd previously been involved in accidents. On July 27th of 21, he struck a parked car, again, not a moving object, just like the house. And then he also had received a 2-day suspension in March of 2020 for leaving his truck in gear when he got out of it, and it rolled down and struck an alley. So viewing the totality of the circumstances, Metro Water Services felt that they could not entrust this employee to be back behind the wheel of a vehicle. I will note that Mr. Burham did not appear for the civil service hearing. He also notified staff that he will not appear today.
Okay, so in essence, we have a default.
Correct.
All right. Are there any questions of Ms. Ladd concerning these items? I'll entertain a motion to approve the initial order of default and dismissal.
So move.
Second.
All in favor?
Aye.
Be approved. Thank you, Ms. Ladd, for being with us this morning. Item number 2 on the agenda. Initial order, Latanya Lester. Hello, come on up.
Can we put this off later to the agenda? The attorney for Ms. Lester is hung in traffic right this second.
Certainly. We will pass that till she gets here, or he gets here. Item number
Briefly, Chairman Farmer, I was going to let you know that Ms. Ruby Joyner is here to talk about DCSO policies. I don't know where if you want to do that today, or do you want to do it at another time?
talk about which policies?
DCSO policies is is Chairperson
Commissioner
Sanders?
Yes, we would like to do that, but can we pass that as well, just when we get to the regular agenda? Thank you so much.
I just wanted to let you know. Thank you.
Thank you for sharing that with us. Item number 3, I understand, has been withdrawn. Item number 4, Nashville Police Department employee Joshua Hausman is requesting to extend his IOD time.
Good morning. Seth Waltonbaugh with MNPD.
Okay, and there's Monica.
It's Monica Anderson, Metro Human Resources.
All right.
So I believe you have the request letter from Officer Hausman. He's only asking for about a 7-day extension due to some delays. Often between diagnosis and surgery, scheduling the surgery, there can be a delay of a month or more. In his case, I think it was around a month, but he's just asking for an extension to November 9th.
Okay. Any questions concerning the request? I'll entertain a motion to be approved.
Motion to approve.
Second.
All in favor? Will be approved. Thank you. Item number 5, Metro Nashville Police Department employee Micah Wright is requesting to extend his IOD time.
Yes, this one's similar. Officer Wright is here. In speaking with him this morning, he did indicate that although the staff report says September 5th, his doctor appointment is actually September 15th. So if it's possible, we would like to ask for an extension to September 15th so that he can be released from his doctor. He expects that to happen, but I didn't want him to lose that 10-day period. Again, he's only asking for about 2 weeks of an extension.
You can only get this once, right?
Sir.
Okay. So any questions?
Let me understand. So are we voting on September 5th or 15th?
15th.
Okay.
Are there any questions?
Just a request we make that part of the motion, just so there's a record that we changed it.
We're going to entertain a motion to extend the IOD time to September the 15th for Mr. Wright.
I make a motion to extend it to September 15th.
Second?
Second.
All in favor?
Aye.
That'll be approved. Item number 6, Nashville Fire Department and Metro Legal request the addition of Civil Service Policy 8.286 NFPA Medical Guide Implementation.
Yes, I'm Brooke Fox with Metro Legal. Good morning.
Good morning, Mr. Fox.
What you have before you is a proposed policy to clarify the National Fire Protection Association 1582, which is already a policy of the commission. This commission adopted the 1582 in 1992, back in 1992. What this would do is just make it perfectly clear that the medical examiner can exercise his or her independent judgment over some of the medical issues. And the reason this came about was because we had a a jury trial in particular, it was about someone with diabetes, and there's a requirement that they have 4 blood tests results within a 1-year time period that showed good blood sugar management. And the jury ruled against us and felt like that was an ADA violation, that it was such a strict application. And so we want to make it clear now with this policy change that the commission and the medical examiner has some independent judgment in allowing someone in that same situation to perhaps, instead of submitting 4 A1C readings, these blood draws, perhaps sort of keeping up with modern technology and using other technology that might be available, such as some of these armbands, whatnot, that you can download spreadsheet information pretty easily, or if someone still wants to go to a lab and get 4 A1Cs, that would still be available as well. But this just allows a little bit more flexibility and some independent judgment on behalf of the medical examiner. And I will say, as an update, as this morning, the judge in this case has denied an injunction against Metro and quoted in part our proposed policy, saying it looks as though the Metro and the Commission are taking steps to remedy this, what appeared to be a strict application of the rules. And so because of that, and because this is definitely on the judge's radar, and we urge its adoption, and I'm here to answer any questions.
Which court is this before?
This is federal court. This is before Judge Richardson. So we had a jury trial in May, and we tried to convince the jury that it really wasn't that strict an application. There was some independent judgment, but the jury didn't believe us. The jury ruled against us. I'll put it that way. The jury decided, the jury found against us, is what I should say, in that the NFPA standard as written does look pretty strict, and so it just wasn't perfectly clear that the Metro could exercise some judgment. So that's what this is about.
Mr. Fox, speaking for myself, I would like to give as much discretion as we possibly can to the medical professionals at Metro, because we're not doctors. We just have to review what they say. So I'm all in favor of your proposal. Are there any questions?
There's just one quick item. The Firefighters Association Local 140 emailed us yesterday saying that they support this change as well.
Oh, good. Good. I would think they would.
Yes, and I meant to say this has been reviewed by the medical examiner, the Department of Health, fire department. So it seems like everyone's on board. So we urge its adoption by this commission.
All right.
I have a question. Has Metro Legal looked at it?
Yes, I'm sorry. I'm an attorney with Metro Legal.
Okay. I'm sorry. Yeah, because I was just concerned about, the charter, because we just had the charter amendment for the police, and, there were things we couldn't do because of the charter.
Yeah, absolutely. We have a team. It's not just me either. We have a team of attorneys who are better at this than I am, smarter than I am. I have back here Ben Puckett and Kelly Woodward, and they were with me during that trial. So they saw the whole thing unfold, and we realized, okay, we need to make it clear. So we drafted this policy and then circulated it among the people we talked about just a moment ago, the Department of Health, the fire department. So it's been vetted by all those different agencies.
Judge Richardson has seen the draft?
He has seen the draft. When it was in a proposed state, we explained it's proposed, it hasn't been adopted yet, but we submitted to him in response to the motion for an injunction to explain that we are taking steps.
Gotcha.
Yeah.
All right. Entertain a motion to approve.
Motion to approve.
Second.
All in favor? That'll be approved. Thank you, Mr. Fox.
Thank you very much.
Item number 7, Metro Codes Department hires above base electrical inspector number 1. Good morning. Anderson.
Monica Anderson, Human Resources.
My name's Byron Hall. I'm the recently appointed interim director for the Codes Department.
All right.
We're requesting today to be able to hire 4 electrical inspectors above the starting pay, just due to the difficulty we've been having in the surrounding areas. All of the all of the surrounding jurisdictions have a higher starting rate, and due to the amount of work that we've got, we've actually lost a couple of inspectors to neighboring jurisdictions. There was a state law that was enacted in January of 2020 that changed the requirements for electrical inspectors. Previous to that, we'd always been able to hire an electrical inspector. They had 1 year to become certified through the state. They could actually work and make inspections for that first year. In January 2020, they changed that, and the law now says that before they can legally make an electrical inspection, they have to be licensed through the state to do so. So it's put a damper on us being able to hire someone that's already certified, and it basically comes down to our entry level is not competitive with surrounding counties. We're making the request to hire in at a step 3. That's roughly a little over $3,000 increase over the step 1, but it puts us in the range of our surrounding jurisdictions.
Okay. All right, Ms. Anderson, the department have a position on this?
We recommend approval.
Okay, are there any questions of Mr. Anderson, Mr. Hall?
I just have one question. Do you anticipate that we'll have to make adjustments to some existing employees because of this adjustment?
I'm sorry, I didn't understand.
Do you anticipate that we'll have to make adjustments to some existing employees because of this adjustment?
Currently, no. We don't have any electrical inspectors that are not passed. They're all they're all at step 4 or above, so there's no problem there. The remaining inspectors, the building, plumbing, and mechanical, when the state, when they changed the law for electrical, they also changed for the other trades, but the requirements were lessened instead of increased. So now we still have, the other inspection groups still have a year to become certified, and in the past, they had to have 2 certifications to become certified, to become state licensed. On those 3 trades, they've lessened that requirement to 1 certification, while the electrical inspectors are being held to a higher standard.
Any other questions? Entertain a motion to approve the request.
I move approval.
Second.
All in favor? It'll be approved. Thank you for being with us this morning.
Thank you.
Item number 8, job descriptions revision of advanced emergency medical technician, paramedic, ESM, captain, and firefighter paramedic. Good morning.
Morning, Jamie Summers, Nashville Fire.
Kevin Palmisano, Human Resources.
Okay, Ms. Summers?
We are requesting to remove the F endorsement from the job descriptions that are attached. That is a chauffeur's license or attachment that goes with your valid Class C driver's license that was previously required by the State Emergency Medical Board, and they are no longer requiring that, so we are not either. So we would like to remove that from our job descriptions of the following. One addition, I've made note from Human Resources in the pay plan, we changed this July 1st to collapse the paramedic 1 and 2 classification and just call them paramedics. And in the EMS captain job description that you have, it still references paramedic 2, so we would also just like to drop that 2, the number from it, and just have it consistent with the pay plan, even though it's not noted in on your actual sheet.
Okay. Does the department have a position?
We support these changes.
Supported? Okay. Any questions? Hearing none, entertain a motion they be approved.
Motion to approve.
With the changes.
Yes.
I second that.
All in favor?
Aye.
It'll be approved. Thank you so much. Item number 9. Metro Nashville Police Department is requesting job description revisions. to the police officer 2 field training officer job description.
Seth Waltonbaugh with MNPD.
Monica Anderson, Metro Human Resources.
Henry Particelli, a Metro Nashville Police Department Aviation Supervisor.
Okay.
So this change we're requesting is for the field training officer job description. That is a sworn assignment classification, and this changes in recognition of the kind of unique nature of our aviation unit, which is our helicopter pilots. Because that position requires so much ongoing training, it's really continuous, both in pilots and the tactical flight officers. Those are the kind of the spotters who fly alongside the pilot and kind of monitor different systems and, keep track of suspects, things like that, or vehicles. That is a constant thing, and so this is just recognition of the amount of training that goes into that. We do have certified flight instructors. They all have their commercial pilot license, but this is just a change that gives us that flexibility.
Okay. Department have a position?
We recommend approval.
Is there any questions? Hearing none, entertain a motion to approve.
Move approval.
Second.
All in favor?
Aye.
Be approved. Thank you so much for being with us.
Thank you.
Item number 10. Anita, does the administrative law judges, they got the hearing calendar? Okay. Thank you so much. You want to go now or you want to wait till we have?
Whichever you prefer.
Why don't you go ahead?
Sure.
Updates from our Human Resources Director.
Thank you, Mr. Chairman. Not a lot of updates from last month because we've had a little bit of a shortened month since our last meeting. I would love to provide just a little bit of space and update if Nikki finds it appropriate. As many of you know, there were 4 charter amendments on the August ballot. All 4 of those passed, and one of those does involve the commission. I don't know if I want to just kind of defer to Nikki to review some of those provisions. We briefly discussed it. As you know, for police standards, the military standards have been the charter standard since the inception of the charter. The charter amendment actually allows the commission to adopt an alternative standard. That was an option you all did not have previously. Obviously, you have not considered said standard yet, but all appropriate parties are working and contemplating, I think, a really responsible set of standards for the commission to consider at a future date. But Nikki, would you add anything or certainly defer to you?
I think you've pretty much covered it. So at this time, we just keep operating under the standards until the new proposed standards are provided to the commission for its review and ultimate approval.
Yeah, I'd like to say, much like the firefighter medical thing we just covered earlier this morning, we would like to get as much discretion as we can to the medical examiner's office. So as the police department's drafting these standards, I would urge you to look at as much discretion as you can give to that so we don't have to have these folks come in and request waivers. And Dr. Dodd, we're counting on you to handle this for us. All right. Thank you, Shannon.
Absolutely.
All right, that's, is the LaTanya Lester lawyer here? Are y'all ready?
I'm here, yes.
You ready to proceed?
Yes, sir.
Okay.
Are we all over here? The microphone's in. Okay.
You have to sit close to your adversary, Ms. Collins.
That's all right, I'll live. Although we did have a Zoom meeting last time, so I don't know.
I'm sure you'll do fine.
And I'm going to have Miss Lester sit up here with me in case I need some help, if that's all right.
That's fine. All right. So we have a 22-page initial order that was issued after 3 days of hearings and several witnesses. Metro has the burden here since the administrative law judge decided that Ms. Lester should not have been terminated. And I'd like to refer to page 16 of the initial order. The first full paragraph, I'll just read this and see if we have agreement on what the ALJ is basically summarizing the charges here. There are basically two charges against Corporal Lester. She is charged with violating DCSO policy, employee discipline, which include 9 separate charges, and Civil Service Rule 6.7 grounds for disciplinary action, which includes 7 separate charges, a total of 16 charges. The specific actions Corporal Lester is accused of can be summed up by stating that she allegedly, 1, refused to feed a meal to an inmate, 2, degraded or cursed at that inmate, 3, did not document the lack of feeding, and 4, lied about what happened on September 25th. Now, I've read the order and the briefs, and I think that's a fairly accurate summary of what the allegations are. Would y'all agree with that?
Yes, Chairman Farmer, and I guess I would add that as to number 4, it's a lying about refusing to feed the inmate, but also about whether she documented the feeding.
Okay. Ms. Collins?
Ms. Owens. And I agree that this is correct.
Okay. All right.
There's a lot of nuances within those, 9 separate charges, so they could be worded different ways, but essentially this is correct.
All right. Understood. Thank you for that. I also find nothing in the record that indicates there is a history of disciplinary actions against Ms. Lester. Is that true?
That is correct, Chairman.
Nothing at all?
No, she had only worked for DCSO for about a year.
And she worked for 20 years with Core Civic before this?
That is my understanding, Chairman Farmer.
All right.
That is correct.
Now, we, as the ALJ said, we too are reviewing this record de novo, but we can't do anything with the record itself. That's our job, correct?
Correct.
No reweighing the evidence, in other words, right? Yeah.
Right, correct.
Yeah,
No, we can reweigh the evidence. We can't add to the, we can't add to
Oh, okay.
Can't alter the record. Yes, that's correct.
All right, we can't, there's no new proof can come out. All right, now, it also appears to me that most of these allegations, if not every one of them, were challenged by oral testimony from the witnesses that appeared before the ALJ, correct?
Yes, there was lots of testimony.
All right.
I don't know if you got the transcripts, and not to interrupt you, but there were 6 volumes of transcript from this hearing.
Right, I understand. Now, much like an appellate court, as we look at what the ALJ did, we usually give a lot of deference to issues like credibility of the witnesses, correct?
Appellate courts generally, yes, do that.
Okay. And much of this, in fact, almost all of it, is kind of a he said, she said situation, as I read it. Officer Lester testifies to one thing, the other officer testifies to something else. You got inmates testifying differently. You had one officer, I think, had a coma from COVID after the event that happened, and the ALJ pointed out that his memory may have been off. There was some confusion about whether, when Ms. Lester was first confronted with the allegation as to what date it was, she was not told when and what she was being charged with until after she had discussed this, and she says she was confused about that, which the ALJ believed her credibility. So my question is, what is it you want us to do?
I think that our brief made 4 main points, and you talked about credibility, and it touches on that, and that Constance Mackey was one of the witnesses called.
I'm sorry, could you speak up a little bit?
Sorry, Constance Mackey was one of the witnesses
Pull your
called.
mic up maybe a little bit so we can hear better.
There we go. Called by Miss Lester, and at the hearing. At the ALJ hearing, there was audio introduced from the departmental hearing where Miss Mackey was also a witness. And at the departmental hearing, Miss Mackey was asked, do you remember Miss Lester talking to Lieutenant Torres about inmate Miller refusing to eat? And Miss Mackey said, I know nothing about that. I don't know anything about that. Yet, miraculously, at the ALJ level, she had a full memory of Miss Lester talking to Lieutenant Torres on that day. And she admitted at the hearing that she remembered this after speaking with Miss Lester about Miss Lester's version of events. So, closer in time to the actual incident, Miss Mackey has no memory of this phone call ever happening between Miss Lester and Lieutenant Torres, yet 6-7 months later, and after talking with Miss Lester, she remembers it, which seems to be a credibility issue. I tend to remember things closer in time to when they happen. My memory seems to dissipate, whether I like it or not.
But it's a credibility issue that the ALJ decided in favor of Ms. Mackey's second testimony.
Yes,
correct?
she did. But we call into question that.
Excuse me?
But we take issue with her.
With her credibility decision.
With her credibility decision, yes, that is correct.
All right.
And then we also, the ALJ failed to take into account the testimony of the inmates who said that they heard Miss Lester call inmate Miller a bitch and inmate Miller asking for her meal and not receiving it. And the ALJ failed to consider that testimony.
Well, wasn't the dates mixed up in that, though?
I think that one inmate confused 2 days, but she did say that Miss Lester had said to inmate Miller, I'm not going to feed you. And she also said that that Miss Lester called inmate Miller a bitch. The other inmate, I don't think was confused and said that she did remember inmate Miller screaming for her lunch because that inmate who testified was actually the inmate who received the lunch. And she said, I remember thinking, I got your lunch.
Right. Is there any dispute that the inmate refused the lunch twice on that day?
Yes, I think that DCSO disputes that.
Where is that in the record?
Well, I think the testimony of the inmate who said that she could hear inmate Miller asking for her lunch, I don't think that if an inmate refuses a lunch, she's going to continue to ask for it. Also, if you look at the video, as soon as Miss Lester gets off the phone, because she was speaking with Miss Mackey, she was on the phone at some point when she allegedly talked to Lieutenant Torres, she fed the lunch that was supposed to go to inmate Miller to inmate Knapp, who testified at the hearing. It just doesn't make sense that you have an inmate who's screaming, give me my lunch, but is also at the same time refusing to take her lunch. And then Miss Lester supposedly asked Lieutenant Torres to come and feed this inmate, yet immediately after getting off the phone gives that lunch to another inmate.
The ALJ found that the inmate had refused the lunch twice before she started screaming for lunch, right?
I don't know if the ALJ made that linear finding, but I think the ALJ did find that the inmate had refused the lunch. I think she just didn't take into account the testimony of the inmates.
She took into account Officer Lester's testimony.
Yes, that is correct.
Gave a credibility issue to her.
Yes, that is correct.
Okay. Anything else?
I think that I would like to point out that the ALJ missed the main point about the documentation in that Miss Lester, there was lots of evidence presented at the hearing that Miss Lester had in the past documented all the time about inmates, because whether you work at Core Civic or you work at DCSO, documentation in a jail setting is very important. If it's not documented, it didn't happen, is the saying. And in this instance, Ms. Lester had documented in the past for other inmates who refused meals. She had documented that day that the lunch was complete, and in this instance, she did not. And when asked at multiple levels of the investigation, even when she was aware of what the allegations were against her, she was adamant that she had documented Miss Inmate Miller refusing her lunch, but that documentation was never found. Ms. Lester even alleged that maybe it had been erased from the system, and so DCSO HR contacted IT and asked, could this be possible? Could it be possible that this entry and that she refused her meal was deleted? And they said it's not possible. There is no way that JMS or any of the other DCSO systems can delete an entry once it's made. And that was given no credence or thought in the initial order.
There was some confusion in the order about the policy about documentation not applying to the place where inmate Miller was housed. Is there a policy, or does a policy exist for documentation of failure to take a meal?
There is a policy in place that talks about exceptional events need to be logged. And there was ample testimony from numerous people at DCSO that an inmate refusing a meal is an exceptional event that needs to be logged. Plus, I would reiterate that Ms. Lester in the past had documented when an inmate had refused a meal several times.
But the judge seems to make a distinction between where the inmate was housed as to whether that policy applies or not. Is that correct?
This was a special circumstance because of COVID, where there were inmates in the RHU unit, the restrictive housing unit, and this is where this incident took place. But those inmates have specific ways to document that Ms. Lester had used in the past to document the lack of eating. And so I think the ALJ took issue maybe with the wording of the policy and didn't feel as though not eating a meal was a special event.
But didn't a sheriff's officer admit that the policy didn't cover the area where she was? Officer Torres, I think it was, or?
Lieutenant Torres.
Yeah. Is that right?
Yes. If I may,
I think that is correct.
Excuse me?
I think that what Lieutenant Torres said was that the policy in question applies to a general housing pod.
Not where she was.
Not where she was.
Okay. Anything else?
I think that is, I think that's it, Your Honor. Chairman Farmer.
All right. Ms. Collins.
This was a very long hearing because there were a lot of details within those 9 individual, charges within each charge that we basically went through and disproved most, if not all of them. But I want to focus on a couple of things that Metro has brought up. In the beginning, Ms. Lester was confused about the days because there was one, and because the inmates that testified were confused about the day, because there was one day that was right before where the inmate did not get fed, allegedly, and the inmate refused her meal. The next day, the inmate broke out of her cell, and so there was a lot of memory about that because that was out of the ordinary and everyone remembered it. So there was some confusion on those 2 days between the inmates. But the main issue about the feeding was that there was no policy that anything had to be documented for not feeding an inmate on that day. And if she was in the G-pod, which normally would have been restricted housing, and they normally would have had a SCAR card with which you could document on. Because she was there for COVID and not because she was restricted, she hadn't done anything wrong, she was really a general population inmate, there was no SCAR card. So there was no way for Ms. Lester to document. Ms. Lester still thinks she did document. Even right now, she's writing me notes. I know I documented. So she does believe she documented, but I don't know what happened to that. And the hearing officer basically said it doesn't really matter because she wasn't required to document. She's only required to document if there's a hunger strike, if they miss 3 meals or more. But what happened with the meals is that there was another issue where you probably read it, there was a hospital event where Corporal Lester had to go to the hospital because the corporal has to go along when there's a hospital issue. And in that, she had contacted Lieutenant Torres and said, look, I didn't feed Miller, she refused, you need to go back and check on it again. And much of the argument was that Miss Lester never called anybody, never phoned anybody, and they made the officers and the lieutenants made a big deal about that, but they had the wrong phone number because they were thinking the phone number would have showed up as the main number where Lieutenant Torres would have called from. And so we actually had the Corporal Mackey call from the unit that would have had the phone call come from. I'm not saying that very well.
880 extension
right.
Instead of an 860.
Right, and so it's a wrong number. So there was never any research into that, and so it kind of questioned whether or not they researched any of the details to make sure that they were right. So overall, I think that the hearing officer did a very good job of being fair on both sides. I mean, she, said that we were wrong on some things too, but she took everything into account and looked at the inmates and, said some of the inmates were not, their testimony was not credible because they were saying they could hear every word that was said, but there was no audio, and one inmate testified you couldn't hear what was said in the cell next to you. And that was the inmate that got the meal. So she was telling us what she heard, but she said that she couldn't hear what was being said next door. So for the other inmate, Miller, to say that she could hear that Miss Lester was saying, "I'm not going to feed you, bitch," just was not credible. And Corporal Lester's, and I guess I can call her that now, her reputation precedes her. She is really, really good at her job. She's been doing this for 21 years with literally no discipline in her record. She likes her job. It is very difficult to find people who like working with female inmates. I mean, it's almost impossible. So it's really, a shame somebody with this much training and experience and someone who feels that that's their mission to take them out of this position. And I think that this was a bunch of small little events that were made into a big deal, and it was really a lot of misunderstanding. And I think the hearing officer was very astute and understood that. So we agree completely with what the hearing officer's decision and determination was, and do not think that Ms. Lester did anything wrong at all. In fact, at one point they said you didn't wear a mask when you went back over there, but the hearing officer herself had the video pulled back up and noticed what I didn't notice and what Ms. Lester didn't remember is that she not only wore a mask, she wore 2 masks during that time. So there were a lot of small credibility issues that added up to Ms. Lester being the one that was the most credible out of everyone. And that's what we would stand by. And I'm open to any questions because it is quite lengthy and quite confusing. And if you have any specific details that you have questions about, I'm happy to try and answer them. And I'm sure Ms. Lester can if I can't.
Any response?
I think that I would just point out that there was testimony from Chief Conrad and others that you could hear what is said in the cells. It is a concrete block, sound travels. So if inmate Miller was yelling, the other inmates could have heard it. And comment that I have. We would just respectfully ask that the commission not adopt the initial order and instead adopt the findings of fact and conclusions of law as stated in Metro's appeal brief that we submitted to the commission.
Do you think termination is the appropriate remedy for this?
I think that dishonesty is something that an employer cannot abide by. Everyone makes mistakes. I make mistakes all the time in my job. I'm sure that everyone here would admit that they make mistakes probably on the daily. But you have to own up to them. Even if you made that mistake because your emotions got the better of you. You have to be honest. This is a correctional setting. You are working with inmates who are literally relying on you to get food, to go to the bathroom, to take a shower. They are confined against their will, and you are in charge of them. Your employer needs to be able to trust that you are going to do your job, and that even if you make a mistake, say there's a critical incident where someone does get hurt, that you are going to tell the truth. I think that that does merit termination. She didn't feed her once. Do I think that would merit termination? Likely not. But you have to be honest about it. You need to be able to own up to your mistakes. It's important.
Well, isn't the issue about her honesty a debate about whether she simply misunderstood the questions or misunderstood the timing of the events as opposed to intentionally falsifying a statement? Isn't that the issue?
I think that you could say that was the issue if she had, at not multiple levels of the investigation, insisted that she documented that she had not fed Miss Inmate Miller. But instead, she always insisted, I documented this. And that never existed. And DCSO searched high and low to find this documentation because they wanted to find it.
Okay. Any questions from the commission?
I think you just asked my question about, is this a terminatable offense, or is it a suspension, or someone else were to not feed a tray, would they be terminated, or would they be put on some type of suspension?
Chairman Farmer, can I respond to what she just said?
Certainly.
It was very clear in the hearing that there was no question that this inmate refused her tray. So it was not a question of Miss Lester did not feed, or Corporal Lester did not feed this inmate. That was not even an issue after the first day of testimony. It was very clear that this inmate refused her tray not once but twice, and that even if she had still asked for another one, there were extras and she could have gotten a tray. So Miss Lester never lied about saying that she didn't feed her, forgot to feed her. What she said in the initial interview was that she documented it, and she still thinks she did document it somewhere, and I don't know where. And honestly, it'd make a better case for us if she wouldn't say that, but I'm going to say what she's saying, and she said all along that she did document it somewhere, but it would not have been in the format that the people who were looking for it would have found, because it would have had to have been on a SCAR card, and it wasn't. There were no SCAR cards for this inmate, and she couldn't have created one. So the documentation, I think, is kind of a non sequitur. It just doesn't really matter, because she wasn't trying to lie. She says she documented it. I think she did document it. I don't know where it is, but as the ALJ said, it didn't need to be documented. So it doesn't really matter, because this wasn't a hunger strike. It was one incident, and the meal could have been given to her still. I mean, they make extras, so she could have gotten one for her if she had asked, and she didn't want one.
I think Mr. Bayless just confirmed for me that in the past they have terminated an employee for not feeding an inmate once, because food is a human right. These people are inmates. Some of them have been just charged with crime. Some of them are convicted. But if they want food, it is your duty as a correctional officer to feed them. I wouldn't like it if somebody didn't give me the food that I wanted and I was beholden to their whims.
Is it rare that an inmate would refuse a meal?
I think that it actually does happen with some occurrence that inmates say, I don't want that meal, but you have to, if they want it, you have to give it to them as a correctional officer. That is part of your duty.
Okay. Anything else?
So you don't believe the inmate refused the meal?
I think that there was an exchange of words here, and that I think the inmate probably did want her meal based on what the other inmate said and after looking at the video. And maybe Miss Lester and this inmate had an exchange of words, and Miss Lester just got very frustrated with this inmate and didn't feed her.
So you began that statement with, I feel, so that's your opinion.
Well, after reviewing the video evidence and hearing the testimony of the inmates, it does appear as though there is an exchange of words and some tension in between. Ms. Lester is gesturing and talks, or appears to be talking. You can't hear anything on the video, to the cell more than once. And so it doesn't appear as though it was just a passing, I don't want that meal, and here's what the inmate says, and then it goes on. There's.
Okay, so let me see if I can understand it. That carries more weight with you than the fact that it was testimony that the inmate refused the meal.
Yes.
All right, thank you.
Can I respond to that?
Certainly.
So while I respect my esteemed colleague, I would say that the hearing officer, after watching lengthy testimony and almost seemed to have a photographic memory because she remembered parts of the video that I didn't remember and would call it up, did not determine that the inmate requested food and wasn't fed. After watching the video, listening to all of the testimony, and not just, I mean, there weren't a lot of people on Ms. Lester's side. Ms. Lester had to basically speak for herself in the video. And our evidence that actually showed that some of the things that they were saying were not true. So I would say that that should carry much more weight than what either one of us believe.
Thank you.
And how long has Ms. Lester been terminated? When did it start?
Terminated October 11th of 2021.
Almost a year.
Yes.
Okay. All right. Are there any other questions? Okay. Any discussion among the commission? Well, I for one, have a difficult time not second-guessing the ALJ after what appears to be Judge Collier did a fairly extensive and exhaustive job, not only with the hearing but with her report. And we did not hear all these witnesses. We did not hear Torres or Miller or any of the other people that were involved. And so I don't know how to second guess their credibility without relying on what Judge Collier did. I just don't know how to do that. Because we can't see him, can't hear him, can't cross-examine them. So I tend to be in favor of that. But I mean, I may be the only one. I'm not sure. So. Anybody want to make a motion one way or the other?
I'll make a motion. I move to affirm the initial.
I'm sorry.
Wait, can't hear you.
I move to affirm the initial order of the administrative law judge.
I second that.
Any discussion? All in favor?
Aye.
All right, that'll be affirmed. Good job, both of you. Thank you for being with us this morning.
Thank you.
Thank you.
All right, now, someone was going to address Commissioner Sanders' concern about the policy the Sheriff's Department has in regard to female inmates. Who was going to do that?
I don't think that it appears they don't know.
Miss Ruby Joyner is here from DCSO.
Thank you.
If you'll let me get my laptop out of the way while she comes up here.
Sure, certainly.
Chairman Farmer, if
Yes.
I may. Miss Joyner,
Yes.
I appreciate your coming here voluntarily to appear before the commission. At our last meeting, we had a case in which there were some disturbing facts that were revealed, and I think some of the other commissioners as well had some concerns where there was a male officer who was supervising females in a situation where he said he had his back turned, but he was supervising females in a shower and making sure there weren't two women in there at the same time, and then turning around to look under the curtain to see if there were legs. But if there had been two sets of legs, I guess I had a question is, well, what was he going to do? Was he going to go in there and pull the curtain back? There was also information in the record about the male officers doing bed checks, and the women were in their cells in their bra and panties, and I just felt that was inappropriate. Also, there was information about just the culture of the women, some feeling I guess concerned that if they said something about remarks that were made, sexual remarks that were made, that nothing would be done. Now, I will say, I appreciate the fact that the contract with Core Civic was terminated. I think that was a good thing, and I know that was done on short notice, so there were only about 3 or 4 months between the time that the sheriff's office had to take over all of that, and there was a lot in terms of getting the employees, and I guess even in this record that we just considered today, there was information about lack of training of the personnel. There was not time. They were given these long policy and procedure manuals to read on their own time, and really did not have time to read those procedures and did not get on-the-job training. So what I'd like to hear from you is what is being done in the situations with the female persons who are in jail, as well as training so that the system will be, so that the inmates will be safe.
Thank you all for allowing me to come here today and speak to you.
Could you remove her mic?
I'm sorry, could you
Thank you.
state your name, both of you, for the record, please?
Right. And I'm just getting back from New Orleans, and so I'm a little throaty, but I did test negative for COVID.
Okay.
Well, it wasn't Mardi Gras down there, right?
It almost seemed like it.
All right, all right. Could you identify yourself for the record, please?
Yes, I am Ruby Joyner. I'm the facility administrator at the Maximum Correctional Center for Men and the Correctional Development Center for Female, so I have both. I have both facilities.
And I'm Evan Bayless. I'm the HR director for the Sheriff's Office.
All right, thank you.
Well, just to start off, I've been with the agency almost 23 years, and probably 20 years ago, I too felt like, or in my mind, as a graduate from the University of Tennessee, Knoxville and Trevecca with a master's in social work and a bachelor's in social work and psychology, before I came in this industry, I didn't imagine that men would be working where women are housed. But since being in this industry now for over 20 years, I can say that we train officers to work in facilities. We don't train men to work with men and women to work with women. As a facility administrator, I've seen challenges with male officers working with male officers and female officers working with female officers. We offer training in cross-gender supervision. That means, of course, men working with women, women working with men. We offer training in ethics and professionalism, and we offer training ongoing in staff-inmate relations. There are policies and practices in place. For example, and I'm just going to use this as an example, when a man enters a female pod, he has to say male officer in the pod, and likewise for the women. giving them ample notice that there's a cross-gender in their area. When the women are in their cells, there is a stated practice and policy that they are to be fully clothed unless they are in their bed covered up in a blanket. Does that happen all the time? No. They are not. Following the rules is a struggle sometimes for officers as well as inmates. I have had issues with male officers working with the females. I have had issues with female officers working with females. There's a lot that we can do in training. There's a lot that we do in training. There's a lot required in annual training. But one of the things that we can't do is regulate morality. Your moral compass is your moral compass when you come on the job. It is what it is, whether you, let me just say, there was a time that I was awfully impressed with resumes and years of training and all that they bring to the table. Very impressive stuff. But doing the right thing, even when there's nobody watching, is sometimes challenging for some. I'm there a lot. I watch a lot of cameras. I listen to a lot of inmate phone calls. I'm very present. They know who I am. But I also have some extremely good chiefs managing those facilities. Sometimes people do the wrong thing, and we hold them accountable for those things. So I, too, kind of, as listening to you as you were beginning and you were speaking, 20 years ago, I would have never imagined that there would be a man in a female facility. But again, we don't train men for male jobs and female for female jobs. We train officers to do the right thing and to do a good job. And when they don't, we defer to human resources, we defer to our policies and practices. And we are, across the board, a huge fan of holding people accountable. And that is a job in and of itself.
Well, with respect to training, there was an issue in this case we just heard about, the officer, saying that, she did not, receive, the training when the transition occurred from Core Civic to the Sheriff's Department. Has that training occurred for all of those employees?
When we took over Core Civic, and I'll yield to my HR director when he needs to jump in, but when we took over Core Civic, they had the women. I don't know what Core Civic practices were. Our practices, and I'm a fan of the DCSO, I worked there, I love working there, I would say that our standards were higher, or higher. We took over a lot of those staff who wanted to stay, who were able to meet certain criteria and were vetted by HR. We gave them, going in, just a sampling of some of our basic policies, some of the ones that are most important: staff-inmate relations, professionalism and ethics, and some of those things. They came in. There's ongoing training. They're staffed under folks who've been with us for a long time, and we assisted them along the way. Some things, I don't care where you come from, there were some things that never changed. One, you're truthful. You tell the truth. You own up to when you make mistakes, and you document. And those are just some basics. So know that they may not have gotten the full gamut going in that we give an officer from the streets, but we prepared them as much as possible for the transition from their world to our world.
I also just want to discern a couple things. The case before that dealt with this male officer supervising the female inmates, he had been an officer with us for at least 6 or 7 years. He was not a Core Civic employee. And so this other case that you just voted on with Ms. Lester, yes, she was a Core Civic individual that had that 20 years of experience with Core Civic. There was a transition period where we tried to get them the bread and butter as far as what we do, knowing that over time we would be able to enhance with some online training, on-job training. All of that did take place, has taken place, continues to take place. We continuously train our officers annually. But in this particular case that was settled before, in which you wanted to talk to us about, that particular officer had, like I said, had been with us for a number of years. And he was literally just acted out. I mean, you can have a policy all day long, but if a person doesn't follow it, we can say, hey, this is how you do this. He chose not to do it the way that he was trained to do it. So I just want to make sure that we don't confuse those two circumstances, because they are entirely different.
Anything else, Ms. Sanders?
No, I guess that's it.
Well, I appreciate y'all coming in. Also have a somewhat of an understanding of how difficult the job must be for everybody over there. And thank you for your service.
Yeah, I just would add, I mean, a number of people kind of said maybe you can't compel us to come here, so maybe we shouldn't talk. But we want to tell our story because it is a difficult job. Not a lot of people understand what we do. So if you have questions or concerns as far as how we do business, I felt like, you know what, let's take this opportunity to educate you, to say this is how we do it. So no problem coming forward and speaking about it.
All right, we appreciate you.
Absolutely not.
Thank you very much.
Oh, I'm sorry. Thank you.
Is there any further business to come before the commission? Hearing none, we're adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.